today. Jeff has helped 33 Capital and myself personally, Sean personally on deals. Will you raise your hand, Tricia?
I just want to make sure we're recording. I didn't see anything recorded yet. I'm like,
wait. Okay. Yep, I see it up there now.
We just started recording. Yep, it just should have just come through. So everyone, we're recording. Just so you know.
So he's a very trusted attorney. He's done everything for us, from helping us buy deals and closing them to selling the deals, and then actually putting the deal structure together where we're syndicating the money. We go out and get investors, put the investor packages together. So today, what I wanted him to cover, because I think it's incredibly important topic, and he's very trusted in my world, are the actual closing of the deal and things that you need to be looking at from a legal perspective and what you should be asking your attorney there. And then also, for those that need to raise money, like myself, and don't have all the money, how you actually put that legal structure together and some of the partnership structure. So it'll be a really valuable experience. And I will turn it over to Mr. Woods.
Thank you so much, Drew. So I'm going to upload slides, and hopefully I do this correctly. Are you guys seeing those?
Yes.
You got it? Okay, good. All right. So as Drew said, I'm an attorney. I've worked with 33 on a number of transactions. I'm looking forward to talking to you guys today. I appreciate you guys taking the time. We're in the middle of February. It's been snowing for the last week. It's below zero. So it's good to talk real estate. Hopefully it's informative. I told Drew I want to make it, informative, fun, energetic. I want you guys to be able to ask questions as they come up. So feel free to interject at any point in time if you have any questions. So this is a quote that, is one of my favorite quotes in terms of investments and in real estate. So Benjamin Graham is a famous investor. He was more stock investor, but this is saying an investment operation is one which through a thorough analysis promises safety of principal and an adequate return. Operations not meeting these requirements are just speculative. So in terms of an investment, you're buying properties, you're investing in real estate, there's really two components to it. There's financing and then the legal side. I'm going to talk about both today. I'm going to cover raising private capital and then legal issues. And you have to be solid on both of them. You have to do your due diligence on both because they both can impact your return. If you've got a legal issue or a financing issue, all of those can impact your return on your investment. So a brief introduction. I've been a licensed attorney since 2004. I practiced at a larger firm right out of law school for around 5.5 years. At the law firm downtown I was at was around 100 attorneys, and I did primarily mergers and acquisitions and commercial real estate. So a lot of the principles that I'm talking to you about today, I learned right out of law school at a larger firm downtown. And I've been on my own for the last 11 years, which is crazy to think. And when I started out on my own in 2010, that was a really, really tough market. And that was foreclosure crisis, ton of foreclosures, short sales. That was back when you could get properties for, 15 grand to 100 grand. It was a totally different world than it is now. But because I started in that sort of real estate world, I started working with a lot of investors. So I have a lot of experience working with investors, investment types of transactions. So right now I'm focused on real estate, investment, fund formation, raising private capital. I'm also a licensed broker. And before we all got on the call, I was sharing a story about, some apartment buildings that I own in the city, and got the dreaded call earlier this week about frozen pipes. So I'm ready for warmer weather for sure. So a little bit of an overview of the presentation today. I'm going to cover financing and raising private capital. And then also in closing, we'll talk about closing a real estate transaction from a purchase perspective and due diligence and what you should be looking for in a purchase agreement, things of that nature. All right, so part one.
I'll jump in real quick, guys. As we go through this, the way Jeff wants to do it, and I agree, is just make it as interactive as possible. So every slide, if you have a question, don't, after the slide is over, don't be afraid to either type it in the comments or jump in and ask. Probably best to actually type it in the comments to start, because we don't have 10 people asking a question at once. But then after that question goes and you want to interact, please do so. It makes the presentation a lot better. And if you don't know something, there's probably 6 other people that don't know it either. So don't be afraid to ask questions on this.
All right. So part one, we'll get into financing. So this is another good quote. There's Sam Zell, famous investor in real estate. And this quote is saying, when it's all said and done, the petroleum of the real estate industry has always been capital. I mean, if you're involved in real estate, you are going to need to raise money. You're going to need to get comfortable with raising money from private investors. You're going to have relationship with lenders. So in terms of real estate and advancing your career, raising money is definitely something that everyone needs to have a level of comfort with. So in terms of financing, there's obviously 2 types of financing. There's debt financing, which we're not really going to talk about today. We're not talking about bank financing, going to a local lender and getting a loan. We're talking today more about equity financing and raising capital. But in most real estate transactions, an investor is going to use both debt financing and equity financing. So here's an example. Investor Hank is under contract to purchase a 6-unit building for $1 million. Hank has secured a loan commitment for 65% of the purchase price, or $650,000, from a local lender. Hank needs to come up with the remaining equity piece of $350,000. So a question to anyone who wants to answer, what are Hank's options to raise the $350,000? Anyone want to come up with some ideas?
Hopefully have a good investor.
Yeah, definitely. I mean, you definitely can use investor capital for that. Anyone else?
Do like sometimes there's a second loan or bridge financing.
That's right.
Give you a piece of that.
That's right. So I think that's a good point and something that I wanted to bring up to you guys. So if you're getting the main loan for the $650,000, that remaining $350,000, you could come up with it yourself, use your own money, which investors typically aren't doing. You might use some of your own money, but you're going to be looking to raise that $350,000. And you can do a loan from an investor, a wealthy individual, or you could do an equity investment where you say to someone, hey, I'm buying this property for $1 million and I'm going to cut you in on the deal and I'm going to give you a return when all's said and done. So just a description of equity financing. It's defined as someone, a person or an entity, putting up money into an acquisition or a business venture in exchange for some percentage ownership in the venture or a preferred return. Equity financing typically involves private investors putting up money, and individual or entities that invest in a company or real estate transaction can be investors or lenders, like I just said. So some forms of equity financing: you could have a simple partnership or joint venture, friends and family money, private equity, private investors, and crowdfunding, which is another form of private equity and private investors. So we'll talk about all these and go through some examples. So going back to our example where the investor is needing 35% equity. He's getting a loan for $650,000. So on the left is an example of investor equity. Hank raises the $350,000 from investors who he promises to give them a 40% return of all profits in the transaction after selling. So that's not a loan, that's an equity investment. So on the right-hand side, Here's a loan example of raising that 35% equity. Hank finds two private wealthy individuals who will each give him a promissory note for $175,000 each at 8% annual interest with a 1-year maturity date. So with these two examples, the one on the right with the loan example and the promissory note, that's a contract. That is, Hank has to give those investors 8%. That's a binding contract where no matter what happens with the project, if he makes zero money, if you sign a promissory note to an investor, you are giving them that return no matter what. If you don't give them that return, you could be sued. So with the other example, with the investors and the 40% of all profits, there's no guaranteed return on that. If there's no profit, those investors don't get anything, and they don't really have any legal standing to enforce anything against Hank. So just kind of a comparison of the two types of equity. It could be investment, a straight investment, or it could be a loan. All right. So next one we'll talk about is a simple partnership or joint venture. So a partnership or joint venture is when two or more parties combine resources for a specific development or investment. The parties in a joint venture maintain their own business identities while working together to complete a deal. With a joint venture, you can parse out and assign responsibilities, percentage interests, and profits however you want. And that last point is the profits are shared however the parties agree. So here's an example. So Bill and Ted each have an LLC that they previously formed for real estate investing. They decide to partner up on the purchase of a 2-flat in Chicago to fix and flip. They have an attorney draft a joint venture agreement for Bill and Ted's excellent joint venture.
Nice.
I'm dating myself with that one, right? The joint venture provides for responsibilities for management, profit split, capital contribution, among other things. So that joint venture agreement can say whatever you want it to say in terms of an agreement between the partners. And this is something that a lot of times right when you're starting out, when you're a new investor, a lot of times you're doing a simple partnership agreement or a joint venture agreement with another investor.
So I'll add into that, Jeff, is just from a practical standpoint. The first deal that Eric and I tried to go out and raise money for, because we didn't have the experience, because that's the side of this, right? You can go out and try to get friends and family money, but are they really going to give you $500,000 when you've never done this before? So
That's
one
right.
of the things that he did is we still raise money, but we would do a joint venture with someone with experience. So then we can lean on these guys' background. So we have to give them maybe half the deal. Now we go out and we raise money and people felt good or better about you or better about us because now we've got people that are doing it with us that have a really good track record. So, you know, as you go on, you won't need those partners. You'll get that track record. You'll have those investors. So you don't need to share. But in the beginning, a lot of times, to kind of get over that hump, you may need that.
I agree. Definitely agree. Okay, so moving on from a joint venture and a partnership, we'll talk about friends and family. So again, when you're starting out, before you have any track record, many new investors use friends and family money as a source of private capital. As we talked about earlier, it can either be debt or equity. It can be a promissory note or a direct investment with a return. Many times it's undocumented, which I think is never a good idea. Even if you're getting a loan from a family member or friend, I think you should start out your investment career with good habits and document it. So, example. Real Estate Ralph is looking for his first deal and finds a foreclosure 2-flat to purchase for $200,000. Ralph's father has indicated that he will provide a $300,000 loan for acquisition and repair. All right, question. So what documents do Ralph and his father need for this transaction, $300,000 loan? Anyone willing to give me an opinion as to what documents they need for a $300,000 loan?
$200,000.
All right. So with a $300,000 loan from Ralph's father to Ralph, you should have, or they should have in place, a promissory note and a mortgage. So this is described as a $300,000 loan from Ralph's father to Ralph. It should be documented with a promissory note and a mortgage that's recorded on title to the property. All right, next one. So private investors. So after you kind of do joint venture partnership agreement, after you do friends and family, if you're looking to expand and grow your business beyond those initial stages, investors typically seek to raise capital by obtaining funds from a larger group of private investors. So this type of capital raising is also known as private equity, an equity fund, or a syndication. So when you're looking to raise money like this, you're typically called a sponsor, and you raise a pool of money with a target or preferred returns to investors. Typically, your time horizon of the investment that you're telling investors is 3 to 7 years, and it's an illiquid investment, meaning when these investors give you money in these types of equity funds or syndication, they can't get that money out until there's a sale of the property. All right, so here's a description between a syndication and an equity fund. So in a syndication, you're really targeting one property. So on the left, an example, ABC Investors, LLC, have an office building under contract and need to raise $2 million from investors to complete the transaction. ABC Investors, LLC is engaged in a real estate syndication transaction where they're raising money for a specific deal. They've identified an office building, they're shopping it to investors and saying, hey, we've got this building under contract, we want you to invest directly into this project for this building. And then on the right-hand side, an equity fund is ABC Investors believes that they've found a niche investing in apartment buildings in emerging market college towns. They have no deals in mind, but want to raise $10 million from private investors so they're supplied with equity capital to carry out their investment objectives. So with an equity fund or private equity, you don't necessarily have a property in mind. You're going to investors and saying, hey, this is our investment objective. We're going to be putting the money towards this sort of project. Nothing in mind as of now. We're raising the money and we're essentially going to go shopping and find deals.
I have a question, Jeffrey.
Please.
When you're doing a syndication, let's say the property is under contract, is there a specific time frame for that they have to raise this capital?
So that's a really, really good question. You know, a lot of times if you have a property under contract, you'll have a financing contingency. So let's say your financing contingency is 21 days or 30 days, or, you know, if you're raising private money as well, you'd probably want it to be 45 days as long as possible. But within that financing contingency within your purchase agreement, you should try and finalize your capital raise within that time frame. If you introduce that sort of contingency, or if you say to the seller, hey, I need to get bank financing, and then I also need to go out and raise a few $100,000. I don't have it yet, but I need to go out and raise some money to complete this deal. The seller's probably going to be turned off, right? So a lot of times the equity raise, if you're raising money, that's more on the hush and on the down low, but you would wrap it up with your financing contingency within the contract. Does that make sense?
Got it. Yes. So essentially, it's just like a normal real estate contract. It's just built in when you create your offer and
right.
All that.
And then I think if you find out that you're not going to be able to raise the private funds, you know, if you go out to some people and the clock's ticking and you're not going to be able to raise the funds, you're going to have an out in that contract, you know, related to financing. You might have to have a lender give you a rejection letter or something. You're going to have some contingency to get out of the deal and get your earnest money back. So again, you could maybe have the due diligence period extended or inspection contingency extended and frame it that way to try and secure the funds. You just need to have some out.
Got it.
Most closings, Gabby, that's a great question. Appreciate you speaking up. Most closings on multifamily are be between 30 to 60 days. I mean, they're going to try to push for 30. So if you can get the way I usually look at a financing contingency is when I'm making the offer, I try to push it back 1 week before close. So it gives me the most amount of time to ensure I have got that loan set, because your due diligence, so your inspection period, your legal period, usually end in the first week or two. And the only way you
Right.
can get out of that contract then pretty much is going to be on your, what's that?
I was just going to say, ultimately, it brings up, another point, which I think, if you're in real estate and in business in general, it's about relationships. And, I think it's important to cultivate relationships and have contacts with potential investors lined up before you even have a deal in mind. Because if you get a property under contract and, Drew, you said 30 to 60 days, if you're starting from scratch and don't have the relationships and don't have the contacts, you're going to really be hustling to try and secure that capital. So, I mean, I think always be planning and relationships and with a deal in mind, and you're going to need money in the future. And when you get a property under contract within the first 5 days, I think it's ideal. And you guys should endeavor to be in a position where you can contact a handful of people within, 5 days of getting under contract and say, hey, let's sit down. Hopefully COVID's done, so you can say, let's grab a cup of coffee. I want to introduce something to you and see if you've got any interest in it.
Thank you, Jeffrey.
No problem. Okay, so when you are raising money like this, there's certain legal issues that come into play. When you're raising private capital or equity, the investor, you really turn into a salesperson. You turn into a money manager. And like I said, going to get a cup of coffee with someone, you're really selling an idea, an investment in a business. SEC rules come into play, and more investors get into trouble in this area, and it's a landmine of problems if you don't do it properly. So you definitely 100% need to get an attorney. And in 18 years of practicing law, I've received a ton of calls of issues that clients have had, investors. So it's something you guys need to get comfortable with if you're pursuing this sort of activity, and really align yourself with some good professionals that can advise you. So here's some examples of fraud. In terms of passions of mine in real estate, there's nothing that gets me going more than when someone commits fraud. I hate it. I hate when I receive calls from clients that, are 65, 70 years old, and they say, yeah, I gave $100,000. It was my savings. I gave it to someone and I haven't heard from them. I can't find them. Literally nothing makes me more upset than that sort of call. And I've received several of them. So, I mean, I'm bringing this up because I want you guys to avoid any sort of, I think my point is, when you're raising money, you have such a high threshold. Your duty becomes so great to the people that you're borrowing money from, and you're a safekeeper of their money. You need to return their money with interest. And it's not just about you at that point in time. It's not just about the real estate project. It's safeguarding and protecting your investors' money. So here's a SEC shuts down equity build. Company claimed to be investing in Chicago real estate, $135 million real estate Ponzi scheme. Ridiculous. Another one, another fraud, local apartment landlord, SEC lawsuit, Ponzi scheme, defrauded investors of nearly $42 million in unregistered securities, more than 300 people. Another one. I mean, these are happen all the time. And I think
something cool about this is we were involved in both of those cases
So this guy, I knew. And what's even crazier, so 33, you guys brokered some of Glenn Mueller's properties were taken over by the SEC. So what he would do is he would book appointments or seminars at hotels, and he would find elderly people who were retired, and he would accept their money, and he would buy. It's greed, right? It all boils down to greed. You accept money. It takes a strong-willed person, someone doing the right thing, to say, all right, I have a ton of money, right? And he would take this money and he would buy cars and he would buy, vacation properties. And I think, the intention of these people that scam is, well, I've got all this money, I'm just going to pay it back. And I'm not going to get caught, and I'll borrow some money and I'll pay it back over time. But then they get in a hole, the property doesn't do as well, and they just need to bring in more money to repay people who are unhappy. And it's this huge scheme. So in my eyes, like, if you accept, let's say, $100,000 from investors for a real estate project, and you take 1 penny of that and buy a gumball, instead of putting that 1 penny towards the property or the investment, it doesn't matter if it's a penny or it's fraud, right? So again, nothing gets me more upset. And, it takes a professional, it takes someone with, whatever, strong moral character, but it's just something to be aware of, that this is kind of a landmine of muck and fraud. All right. So the SEC is involved. So I want to talk about, why is the SEC involved? And really the differences between a public company and a private company. So if you're a public company, you're registered with the SEC and they sell stock on public exchanges. Public companies provide quarterly and annual reports to the SEC. So the general public has information to make informed investment decisions. If I want to buy shares of Amazon or Google or Pepsi or Coke, I can go online and I can review gobs and gobs of information on these companies. So the SEC is okay with these companies selling their stock to the public. So with this sort of private investment that we're talking about, a private company is not registered with the SEC. So if a private company is issuing or selling securities or stock or shares of their business, the SEC is concerned about the lack of available information to investors. They're concerned about the elderly people that, they have 401ks and IRAs, and they want to make sure that they're protected. So the SEC requires a private company to issue certain information to investors, and they require the company to register the offering or the sale of any securities / stock with the SEC. And a lot of times people don't do this. A lot of times people raising private money don't register with the SEC. All right, so an example. Joe, Tom, and Pete operate JTP LLC. They want to raise $500,000 from outside investors and contacts that they have in the real estate industry for a real estate transaction. Question: is JTP LLC engaged in selling securities so that they need to register with the SEC? Anyone care to guess?
Isn't it just over $1 million?
Nope.
Uh-oh.
Nope. So the answer is yes. There's no threshold as far as dollar amount. So if they're raising $500,000 from outside investors, the SEC would say, we want to know about it. We want to know who you're selling to, or we want to know how much you need to give information to an investors. We want to make sure that we know about what you're doing. So it doesn't matter the dollar amount. It could be $100,000. It could be $500,000. So I think the only issue, though, is in this example, outside investors, right? So if it's friends and family, do you need to register that with the SEC? I would say probably not, because it's family and friends. But once you go outside the family and friends realm, then it's definitely something that you need to report. to the SEC. All
How
right,
do you
so the
do
SEC, what's
'Cause I
that?
don't even know. How do you do that? I'm not,
Report to the SEC?
do our attorneys do that? Or is this something
They
that
sh-
we're supposed to be doing?
The attorneys should.
Okay.
The attorneys should. So SEC, some guidelines. So they've got a couple of rules that investors typically follow. And this is Regulation D under the Securities Act of 1933. So there's Rule 504 and 506. So Rule 504 allows a sponsor company to raise up to $5 million in a 12-month period. Drew, this is what you're talking about, who files it. You file a Form D with the SEC within 15 days after the first sale of a security or first sale to an investor. Form D is a brief notice. It's literally like 2 or 3 pages long. And it just includes information on the company that's raising the money, their officers, directors, and some details about the offering, how much you're raising, what time period, etc. So one important caveat is that there's no general advertising or solicitation unless you sell to accredited investors. And we'll get to the definition of accredited investors soon. You must also comply with state laws. There are state securities laws. So you definitely, if you're doing this sort of thing, you definitely need an attorney. So I'll back up. In the general advertising and solicitation, you cannot engage in a general advertising or solicitation to raise money. So that means you can't go to a hotel and rent a conference room and invite a bunch of people. You can't put ads on the newspaper. You are not supposed to do internet marketing, Facebook, social media, etc. So what that's getting at is they really want it to be people that you know or have some contact with. They want it, not necessarily family and friends, but colleagues within the real estate world or referrals. So they don't want general advertising and solicitations. I think I just answered this question. So back to JTP LLC, they're seeking to raise $2 million. They book a conference room, banquet hall at O'Hare Marriott, and send an email blast and social media blast for all their contacts to attend the seminar. Is such a seminar legal? So I already answered it. I'll answer it again. The answer is no. I mean, you cannot do a general solicitation. You can't open it up to just anyone to come, and that would be a violation of the securities laws. All right, so Rule 506, this is more advanced. So Rules 506 and 5B essentially allow you to raise an unlimited amount of money, but essentially you're only going to be selling to accredited investors. So we'll skip ahead. Accredited investor, the definition is an individual with a net worth or along with their spouse of $1 million, not including the value or any equity in their primary residence. So you have to have a net worth of $1 million, or an individual with income exceeding $200,000 in each of the last 2 years, or $300,000 jointly with a spouse. Or it could be any director, officer, partner of the sponsor company. They're considered an accredited investor. So with these sorts of deals and raising capital, a lot of times investors only seek out accredited investors. If you do use non-accredited investors, there is a concern about more disclosures that are required. The definition of a non-accredited investor is someone who's sophisticated, and they must have sufficient knowledge and experience in financial and business matters to make them capable of evaluating the merits and risk of an investment. So those are 2 definitions, but like I said, a lot of times, I think as you go higher up in dollar amounts and the higher money amounts that you raise, you're targeting accredited investors. So when you're putting together something like this, an equity raise, the main document, the main disclosure document that you're giving to investors is called a private placement memorandum. And it should be used with both accredited and non-accredited investors. So a private placement memorandum typically contains the following. Description of the investment opportunity. Is it a syndication or a general fund? What are you targeting? How much is being raised? Use of proceeds, what you're using the money for, target returns to an investor's and investment timeline, the risks associated with the investment, and a description of the sponsor and its principles. Okay, and then when you're bringing in investor money, when an investor says they want to invest, typically you have them sign a subscription agreement, which indicates the number of shares that they want to purchase and the price. The offering will typically indicate that there's a minimum investment, let's say $50,000, and the offering will indicate the number of units or shares being sold, i.e. 40 units. So in this example, if you're selling 40 units at $50,000 per unit, you're looking to raise $2 million. Reporting, so money raised from investors should be put into a segregated account until all investor money is raised. After the first money is raised, as we indicated earlier, you have to report it to the SEC. And the sponsor must also register and report with every state in which an investor money is raised. So as an example, if an investor is from Wyoming, you need to contact the Wyoming State Securities Division and verify any requirements you need to comply with them. All right, so here's a description. If you've raised private money, what you're typically returning to an investor. So as an example, Brookfield Investments raises $750,000 from 3 investors who each put up $250,000 in order to purchase an apartment building. Brookfield told the investors that they would receive an 8% annual preferred return and split any remaining profit 60-40, 60 to the sponsor, 40 to investors. Total profit after sale and fees is $850,000. So if this investment was held for 3 years, you need to return investor money at 8% for each year. So 8% based on $750,000 invested is $60,000 of preferred return interest each year to the investors. So times 3 years, you have to give the investors $180,000 on their 8% preferred return. With the $850,000 profit, after you deduct the $180,000, you're left with $670,000. Remaining funds, $670,000. And then pursuant to the 60-40 split, the investors receive an additional $268,000, $670,000 times 40%. And the sponsor would receive $402,000, $670,000 times 60%. Does that make sense?
So Ben was asking about this should help answer some of your question, Ben, on typical structures. This actually looks like a typical structure that 33 Capital would do. It's a little bit different, but it looks like what we did on Oak Park. So well, a lot of times what we'll end up doing is there's a 6% return on the money that's invested, which he just went through, but in this case it was 8%. And then after the investors, now there's a million ways to skin this cat, but this is the way we do it. After the investors are 100% paid back their initial money plus the interest, then that's when we get, that's when the general partnership or the principals get into the money. So at that point, any cash flow coming out of it for us, we usually do a 50-50 split, but when we started, it was 70-30 or even 80-20. You basically
That's right.
create the split so that, you know, the more money that comes back to the partnership, the better, and the better you get at this, the more people will invest with you as basically as you go, because they trust that they're going to get that return. So when you hear like a split, that's between the general partner, which the general partner is the guy putting the deal together, and the limited partner is the equity, typically the money that they're putting into the deal. So that GP LP split you'll hear talked about all the time is general partner limited partner split, and that's 50-50. then that a lot of times that means when the investors are paid back, the general partner and the limited partner will share 50% and 50% of the proceeds. And then they call it pref. You'll hear pref all the time. All that is an interest rate or an annual return based on how much money is still in the deal that you have to pay those investors to have that money in the deal.
Okay.
Does
That's
that
really
make
helpful.
sense, Ben?
Yeah, it does. Hopefully you can hear me. Just
Yeah.
one small question, and this might be I don't know if there's a specific way to answer this, but between preferred return being, I've seen 6 to 7, 8%, and versus the split where right now we have 40 to 60, for investors, when they're looking at that, which of those two items is a bigger deal to them? I'm assuming the preferred return is like because that's in stone kind of, but
I think so. I think, when you've got to look at investors who, if they're investing in a property like this or an investment like this, they're not wanting to put their money in the stock market. They think it's overvalued. They don't want to invest in mutual funds or, whatever. So I think for them, they're looking for a safe return. They want some guarantee that they're going to get 8% on their money. They want diversification. So in my opinion and in my experience, they're more concerned with the preferred annual return, and everything else on top of that is just gravy. And, Drew mentioned when you're starting out and you're looking to raise money and you maybe don't have the track record that an investor wants, you might have to say to him, look, here's the deal I've got, I'll give you a 10% preferred return. And then, this 60-40, you might have to say, on top of your preferred return, I'll give you, 80% after your preferred return, and I'll take 20. I'll take 30, you take 70. You might have to induce them or sweeten the deal for them to make it something that they can't refuse.
Okay. It's really helpful. Thank you.
Yeah, no problem. So I think
There's
additionally,
and just to add into that, a lot of times when we're going to market with a deal, these are kind of levers you can pull, right? To some people, he's right. The preferred return is the most important. The guys that are really into real estate, they may want a bigger piece of the back end or a bigger piece of that profit on the split. So a lot of times you can kind of cater to your investors and your investor base, but maybe if you're doing a 10% preferred return, that is 10% on their money, a lot of money. So then on the other side, you should be getting a better split of that deal. You should be getting the lion's share of that, of what we'll call the GP-LP split. If you're giving them a 6% return or 4% return on their money, they may get the lion's share of that. It really both vary. I know personally speaking, I like the preferred return, the safe return, but if I know the deal is going to work out really well and there's going to be a lot of value added, I'll take the GP-LP split behind it all day. Because if you get in the deal, you refinance it, which in a year, if you're doing construction, you refinance, you give them all their capital back, their preferred return is gone. That's a year of preferred return if you're doing a value add deal. And on the other side, then it's all just cash flow from the rest of the time. So it really depends on the deal structure, the sophistication. If the deal is really good, I want a lot more of that GP-LP split because you're adding value, and now it's maybe for the next 10 years, you're getting that cash flow split. You see what I'm saying?
Yeah, it's very helpful. Thank you.
Okay.
All right. So additionally, this next one, we're talking about the GP-LP split and, fees that the sponsor, their return at the end. But as a sponsor, you're also getting additional fees typically. So the sponsor typically gets an acquisition fee once you purchase the property. And this is all disclosed to your investors. And this would be a negotiation. Acquisition fee. So when a property is acquired, a lot of times the sponsor will get an acquisition fee, 1 to 3% of the purchase price. A lot of times the sponsor will use an affiliated entity for management. They get a management fee. And then additionally, disposition fee. When a property is sold, it's almost like brokerage fees, right? Acquisition fee, disposition fee, 1 to 3% of the purchase price, and then excess profit that we just talked about in the previous slide. So crowdfunding, really quick. I'm not a huge fan of crowdfunding. I haven't done a ton with it, but there's an Illinois crowdfunding law, which is essentially allowing you to raise $4 million in a 12-month period just from Illinois residents. You can do it online. It's mostly online. And the sponsor company, you must conduct the offering through a registered state-approved funding portal. So you're not taking over the money. Everyone goes to this third-party portal site, and the funding portal charges a 3 to 8% fee on the amount you're seeking to raise. Non-accredited investors are capped at $5,000 for an investment. And you must present current financial statements to investors. So a lot of times this doesn't work, or a lot of investors don't want to do it because this is typically small startup. You're raising, $500,000, $1 million, and in theory that sounds great. But the thing that dooms this a lot is a lot of times you're using non-accredited investors and you're capped at $5,000. So I mean, if you're looking to raise $500,000 and you're using all non-accredited investors, you need a lot of non-accredited investors to get to $500,000. So I think the flaw with the crowdfunding, because it's smaller money, typically you're using non-accredited investors, this $5,000 cap is what is really tough and why it's not used as much. But it is out there. Okay, so we're kind of into part 2. We're done with raising private capital. We're kind of short on time. So I'm going to get through this next part. But first, is there any questions on raising private capital, SEC compliance, etc.?
Tricia was just asking why don't you ask your question so everyone can hear, Trish?
Yeah, so I was wondering, why would there be a situation where the general partner is not getting at least 50% of the split? Would that be a situation because they're not putting up any money? They're doing the work and putting the deal together, but they don't have capital in it, so they're giving away more of the split in order to entice investors? Am I understanding that correctly?
I would.
Yeah, and then usually as Jeff was just saying on the fees, so then the general partners, or the guys putting the deal, gals putting the deal together, they get all the fees as well. So you're getting the fees, you're putting no money in, or maybe you're putting a little money in just because the investors want to see you have skin in the game. And that's exactly why. I mean, our first deal, remembering back, I think we were 80-20, 80 to the investors and $20, or maybe it was 70-30. But as we gained trust and everything, now it's 50-50. And we've only done one deal that's less than 50-50. So it's pretty common that investors won't get more than 50%, or not the investors, but the general partners, you don't get more than 50%.
Got it. Thank
Or
you.
you've got a great deal. Like, you've got to be hitting home runs.
All right, so closing a real estate acquisition on the purchase side. So we're first going to talk about entity formation, and then the purchase agreement, due diligence, financing, and closing. So entity formation, options for investors are sole proprietor, general partnership, LLC, limited partnership, or corporation. I don't have a slide for corporation because it's really not used in like the type of investing that we're talking about. Some investors that I work with that just do like fix and flips have S corporations. But for our purposes, investing more long-term, raising private capital, you don't really use a corporation. So sole proprietor, this is my favorite slide. So it's just you. You're it. There's no partners. You don't need to form an LLC. You're not forming any. You're just, individually, you're operating your business. You've got full liability. You don't have any asset protection. A lot of people starting out, they ask me, well, I want to buy a property. Can I just buy it in my name? I'm buying a 2-flat. I'm just going to own it in my name. And I say, yeah, that's fine. You just need to have a really, really good insurance policy. You don't have LLC protection. You don't have, any liability or asset protection, so you could be sued individually. But I always tell clients, residential real estate or owning an apartment building, it's not a terribly litigation heavy field, right? Like you rent a property, people sleep, they wake up, they cook dinner, they go to work, they watch some TV, and they do the same thing again. I mean, most lawsuits related to residential real estate are, I slipped on some ice and I broke an ankle. That's covered under your insurance policy. You should have $1 million to $2 million liability coverage. So if you do own a property in your individual name, just one, it's not the end of the world. You just need to have a really good insurance policy and understand that you have sole liability and can be sued individually if there's a claim above your insurance policy. So next, general partnership. We kind of talked about this early. It's just two or more coming together for a business venture for profit. You don't need to form any forms with the state. It can be a written agreement. You could put it on the back of a napkin. Jeff and Drew are partnering up, buying this property. Here it is. We sign it. We're a general partnership. No forms are needed. So I'm going to skip this example in, let me see. Yeah, I'm going to skip this example just in the interest of time. So LLC. So the LLC is a hybrid between a partnership and a corporation. It has beneficial tax treatment. It's not a separately taxed entity. Limited liability for the owners and members, similar to corporate shareholders. So if you own a property in an LLC and you're sued, there should only be a lawsuit against the LLC. You should not be able to name the individual owners or members of the LLC. With an LLC, you have an operating agreement, and that's allocating ownership interest, capital contributions, distributions, management, termination. Operating agreement can really have whatever you want in it. So we've all heard of LLCs. It's routinely used as a vehicle to invest in real estate. It can be used in connection with raising private capital, which we talked about earlier, and you form it with the Secretary of State. It costs about $250. It can be formed in one day. All right, so that example I skipped. I should have went over it. All right, so here's an example of an LLC. So Fred, Brad, and Chuck have had success in their general partnership. And they decide to form an LLC. Fred, Brad, and Chuck are all members of the LLC. Fred puts up 50 grand in exchange for 50%. Brad and Chuck each put up 25 for 25% interest. So what I want to drive home with this is that you can form an LLC. You don't all need to be equal. Fred owns 50% here, the other's 25%. So that's a negotiation with your partners. Do Brad and Chuck have other jobs and they're just contributing part-time? All of that can impact percentage interest in ownership. So here's another further example of an LLC. This group has had further success and they decide to form a new entity, FBC Capital Partners 1, to raise $1 million from private investors. Private investors will own 40% of the new entity, and FBC Partners, the original LLC, will be a 60% owner and manager. And they intend to file SEC exemption rule 504. They're raising $1 million. So you can see in the chart, there's the new entity, FBC Capital Partners 1. Investors on the left own 40%. And then Fred, Brad, and Chuck own 60% of FBC Capital Partners. And this would follow that previous example that we went over with the 60-40 split. Limited partnership. Limited partnership is an entity that's registered with the Secretary of State of Illinois, typically used as an investment vehicle when you have passive investors. You're required to have a general partner who's responsible for management, decision-making, and has general liability. The limited partnership also has one or more limited partners who merely contributed capital, but they have no rights, responsibilities, and management or voting. They're passive investors. Limited partners have no liability for the obligation debts of the limited partnership above their investment. So as an example, Fred, Brad, and Chuck are hitting it big time and decide to raise $6 million from investors to purchase various apartments across the country. They decide to form FBC Equity Fund Limited Partnership. FBC Partners LLC, their original LLC, will be the GP. and their offering documents will indicate that they're accepting up to 60 limited partners with $100,000 contributions. The offering will be reported to the SEC, not SED, typo, under Rule 506B or C, depending on whether they're going to be using a general solicitation or advertising. So here's that flow chart. So the general partner, or the new entity, FBC Equity Fund Limited Partnership up top. The general partner on the right is FBC Partners LLC. And on the left hand, you have 60 accredited limited partners who are putting up $6 million of passive investor capital. All right, so any questions? We're kind of nearing 1 o'clock. I just have a couple more slides. Any questions on LLC, limited partnership, general partner, or entity formation?
I'm going to add in something real quick.
Sure.
Just from a real estate perspective, and then I've gone through a million of these things. And you're talking about, so LLC, every single property I own is in an LLC except my house.
Mm-hmm.
And I would say the operating agreement, don't make sure that when you have partners on a deal, you know, if there are other partnership and the general partners, so it's, call it me and Eric, or, you know, Trish and Mary, whoever that is, make sure in that operating agreement, what I would do, and it's been successful, is really define who does what, when, and it's really laid out so that, I mean, something as silly as who shovels the snow on a Saturday, and you don't want to get into, you know, too many details, but it just avoids any controversy, fighting, you know, pissed off partners. When you really define and you go into a deal and you've really thought about all the different little things that you guys are going to be doing, who's going to be into taxes versus who's going to pick up tenant calls, or are you going to hire a manager to do that stuff? Those kind of things, whether it's in the LLC docs, operating agreement, or it's in some kind of addendum, do it, because it helps you. And I promise you, I've been in a lot of partnerships. You want to have it very, very clear who does what when you walk into that thing.
Okay, so once you have your entity formed and you've got a property under contract, you're going to need a purchase and sale agreement. So this is rarely a form document or agreement. Once you get up past, you know, 3 units, 6 units, if you're buying multifamily, it's not a form document. It's typically drafted by a buyer's attorney based on asset type, multifamily, office, etc. So the key dates you want to be mindful of are effective date to track other upcoming dates. They're usually based on the effective date. Earnest money deposits, non-refundable date of earnest money. When does the earnest money go hard? Due diligence period and closing date. So in a commercial transaction, if you're not using a standard broker contract, if it's not considered residential, the purchaser does not have the same consumer protections as you do in a residential transaction. So the purchase and sale agreement is really, really important to protect the buyer. So within the agreement, you want to have the seller make certain representations and warranties. Financial representations, tenant representations. You want to find out about rent, late rent, defaults, notices, evictions. You want to find out about code violations, environmental notices received in compliance with all other laws. You want to know about litigation, existing contracts that the seller has in place that impact the property, and taxes. Within the agreement, you need to address seller deliverables. There's typically a section that requires the seller to provide you with stuff within a certain period of time. You want leases, rent roll, contracts, surveys, environmental reports, title policy. So all of these items are typically put in a virtual data room so you can conduct your due diligence with your professionals, brokers, attorneys, etc. So some miscellaneous issues, proration of taxes, security deposits, and rents is always a big deal. You want to have a clause that indicates that the seller cannot enter into any new leases or no new agreements before the closing. You don't want to find out a day before closing that the seller just signed up some new lease at below market rent or signed some new property management agreement that binds you post-closing. If you're buying a property in Chicago that has residential tenants, Chicago landlord tenant ordinance is something you always need to be mindful of. And you want to have some post-closing indemnification so that if you find out some representation within the agreement's been breached, you can go back to the seller post-closing and say, hey, I've got an issue. It's post-closing, but you need to address it. All right. Do we have time for an example? Quick example. So this comes up a lot with multifamily and rents and rent credits. As a buyer, you're going to be getting rent credits at closing. So Ian Investor is purchasing a 12-unit apartment building. Gross scheduled rent is $15,000 per month. Closing is March 5th. Ian's expecting to receive prorated March rent of $12,580 based on the following: $15,000 gross scheduled rent divided by 31 days in March, $483.71 daily rent times 26 days. At closing, the seller indicates that COVID's hit his tenants hard and he's only received $6,000 of rent for March and can only provide a credit based on $6,000 received, but not the $15,000. So your purchase agreement, and this comes up a lot. So you need to indicate in your purchase agreement that the rent credits that you receive are based on scheduled rent and not collected rent. Because the last thing that you want to do is close on March 5th and then have to chase a bunch of tenants and collect rent. They're going to hate you. So you want to be in a position where you get all of the rents credited to you, have the seller chase after any March rent, and then you're looking to collect April rent from the tenants. Do we need this example? I'm going to skip this one. This is about the Chicago landlord tenant ordinance and complying with security deposits. We've already kind of touched on that. So due diligence, obviously very important. So due diligence, you want to review all of the contracts associated with the property you're purchasing. And you want to determine what contracts could bind you as the purchaser post-closing. Laundry contracts. I've seen laundry contracts with coin-operated laundry machines where they last for like 99 years. There's this company in like Franklin Park, and they have these 99-year leases that say they need to keep their washing machine coin-operated in a property, even if it's sold. Landscaping agreements, property management agreement. You want to find out any agreement that impacts your property. You want to review leases, security deposits, rents, when the leases expire, insurance rates. You know, that's something a lot of investors forget to do. You know, when you're calculating your return and what your costs are, find out insurance, how much the property is going to cost from an insurance perspective. Physical inspection. You know, a lot of times investors use the inspection for retrade to renegotiate the purchase price. Financial review, seeking to determine rates of return, net operating income, cap rate, internal rate of return, review taxes, and environmental. So due diligence should typically be 14 to 21 days and give the purchaser the ability to terminate and receive a refund of any earnest money. Earnest money should not go hard until after the expiration of any due diligence period and a financing contingency. Financing, so most real estate transactions will have debt financing. Your purchase agreement should have a financing contingency if purchase is contingent upon obtaining a loan from a lender. Financing contingency is typically 14 to 21 days. Sellers will typically not agree to appraisal contingencies in larger commercial transactions. And then equity financing, friends and family, investor money should be finalized within the financing contingency. Closing should be primarily review. You're going to do obviously a walkthrough, go to the property, make sure everything looks good, review the closing statement, title commitment, and loan documents with your attorney, review the purchase and sale agreement one last time to confirm that you have all deliverables from the seller, arrange to receive all keys, notify tenants of new ownership, secure any vacant portions of the building and rekey if needed, utility transfer, and then the last thing and most important is take your attorney to a nice closing dinner. So that will conclude
Aren't you supposed to take the clients?
What's that?
Aren't you supposed to take the clients?
No,
Oh, come on now.
No, come
Oh,
on.
we're getting paid. You gotta take us to dinner, baby.
Jeff,
So
just
any-
to clarify, is there a target amount the dinner bill should hit when you take your attorney out for dinner? Is that
Oh,
defined?
No, so there's no target amount, but I mean, COVID's such a bummer, to destroy all of the fun stuff. But no, I mean, I'm good with a steakhouse and a nice
Guys.
glass of wine or bourbon, and I'm a happy camper.
Fully noted.
So
Uh,
any questions? No.
So
No?
I'll hang back if anybody wants to talk about anything for the next half hour. Anything real estate related, I'm happy to talk about anything. Answer any questions you guys have about multifamily investment, anything on the Oak Park deal. If not, that's great. It's totally fine. On the other hand, what I'm gonna do, what Meg's gonna start doing is we're gonna send a survey out to all you guys. Because, this is our first year we're doing this on all the different modules, and we're going to do this year over year. So we want to do, a better job of ourselves on improving these things to give you guys what you need. So you have feedback and then rate the meeting. If you want more real world examples, if you want to see more pictures, whatever that may be to help you learn more, different content, higher level, more in the weeds. Please let us know, because we want to keep crafting these, and we want to get better, and we want to teach you guys how to do this yourselves.
No, this was tremendously helpful. Thank you, Drew and Jeff, for the time. And
Yeah, no
everything
problem.
that went into this. This is
Thank
great.
you guys. I appreciate the opportunity, and good luck with everything. If any questions come up, Drew, you can share my email address. I didn't put it up, but feel free to share my email address. If you guys have any questions, feel free to email me or call me. I'd be happy to hear from you and answer any questions outside of the presentation.
Awesome. Thanks, Jeff.
All right,
Thank
no
you.
problem, guys. Have a good rest of your day. We'll talk to you soon.
Thank you.
thank you.
Thank you.
Thank you.
Trish, you want to talk to me more?
Huh?
I just said anyone
Always, right?
has other questions on it or that or anything else real estate, I'm happy to answer.
Hi, Drew.
I miss you.
Miss you guys too. How are you
Hi.
guys?
I'm actually back in the office today. It feels so good.
Oh, I'm so jealous.
Oh, feels good. How are you doing with the kids and everything? Are they back to school, or what's the deal?
Oh no. No,
Oh.
there's like a lot of things with like the CTU and stuff going on. So they've pushed